Your property is now under HOA control for unpaid assessments totaling $87,000. And as of this moment, your lake house is officially seized for delinquent community fees. You have 24 hours to vacate before we change the locks and dispose of your belongings like any other foreclosure deadbeat. That's what Bradley Whitmore screamed at me while waving a fraudulent foreclosure notice. His pink dress shirt stretched tight across his bloated gut, black dress pants riding up as he gestured wildly with his clipboard toward my $890,000 lakefront retreat that had been my family's sanctuary for over 20 years. The smell of his expensive cologne mixed with morning lake mist, and the metallic taste of pure rage as this suburban dictator stood there absolutely convinced he'd just stolen prime waterfront property through some bureaucratic loophole involving fabricated HOA assessments. I'm Judge William Harrison, and for 34 years I've served on the federal bench, including the past 12 years as Chief Judge for the Western District of Colorado, presiding over thousands of foreclosure cases, property disputes, and the exact type of fraudulent seizure schemes that Bradley was attempting to use against my family. But standing there in my red and black checkered flannel shirt, watching this entitled coward wave fake legal documents at the federal judge who literally writes foreclosure law precedents, I felt the cold satisfaction of knowing exactly how this would end. What Bradley didn't know was that in exactly 18 months, he'd be standing in my federal courtroom facing racketeering charges for systematic property fraud, while his entire HOA faced criminal prosecution for conspiracy to commit theft through fabricated assessments and fraudulent foreclosure procedures. And I'd be the one presiding over proceedings that would send Bradley to federal prison for 32 years, while ordering complete restitution to every family he'd victimized through his criminal real estate empire. What would you do if some HOA tried to foreclose on your lake house using fake legal documents? Where are you watching from? Drop a flag emoji and tell me your state, because this story will show you exactly how to destroy foreclosure fraud schemes using 3 decades of federal judicial experience and the constitutional authority to rule on the exact crimes Bradley was committing. My name is William Harrison, and 22 years ago I thought purchasing the lakefront property at Crystal Lake Estates would provide the perfect judicial retreat where I could write legal opinions, while enjoying the kind of peaceful environment that helps federal judges maintain perspective on the human impact of our constitutional decisions. After spending over 3 decades on the federal bench, including authoring landmark decisions on property rights, foreclosure procedures, and homeowner protections, I was looking forward to quiet weekends reviewing cases while watching sunrise paint the Rocky Mountains in shades of gold and crimson. The Harrison family had owned waterfront property in Colorado since the 1920s, when my grandfather, Judge Samuel Harrison, purchased our original cabin on Grand Lake during his tenure as a territorial court judge. The tradition of federal judges owning Colorado mountain retreats was both practical and philosophical. The isolation provided necessary space for contemplating complex constitutional questions, while the natural beauty reminded us that our decisions affected real families living in real communities. My lake house at Crystal Lake represented both a personal sanctuary and a professional necessity, providing the kind of environment where federal judges could write thoughtful opinions without the distractions of urban legal practice. The 4,200-square-foot home featured a judicial library, secure communications for federal court business, and the kind of architectural design that complemented rather than dominated the natural lakefront environment. For 20 years, the property had served as my primary residence outside of court sessions, hosting judicial conferences, constitutional law seminars, and the kind of thoughtful legal discussions that shape federal jurisprudence. The house included guest quarters for visiting federal judges, a conference room for judicial working groups, and library space for the legal research that informed federal court decisions affecting millions of Americans. Crystal Lake Estates had originally been developed as an exclusive community for professionals who appreciated both privacy and natural beauty. The original HOA covenants emphasized environmental stewardship, architectural harmony, and the kind of community governance that respected property rights, while maintaining shared amenities that enhanced rather than restricted homeowner enjoyment of lakefront living. For over a decade, the community had operated exactly as intended. Property owners enjoyed their lakefront investments, while the HOA maintained common areas, managed environmental protections, and facilitated the kind of neighborly cooperation that made lakefront communities desirable places for families and professionals seeking refuge from urban pressures. The trouble started when Bradley Whitmore purchased the largest mansion on Heritage Point Drive and immediately began positioning himself as a community improvement advocate with strong opinions about property utilization, architectural modifications, and what he called underutilized waterfront assets that allegedly failed to maximize community property values through appropriate development and commercial utilization. At 59, Bradley had the appearance of someone who'd spent decades manipulating legal systems for personal profit, while never understanding the actual law that governed property rights, foreclosure procedures, and constitutional protections that federal judges spend their careers interpreting and enforcing. He'd made his fortune through distressed property acquisition, buying foreclosed homes and manipulating legal procedures to acquire real estate below market value through systematic harassment of vulnerable homeowners. Bradley's initial approach seemed collegial. He claimed to represent property owners concerned about community asset optimization and suggested that my judicial schedule might benefit from property management services that would maximize my investment returns while I focused on federal court responsibilities. He emphasized his expertise in residential asset enhancement and implied that judicial professionals often lacked the business acumen necessary for optimal property investment management. The relationship began deteriorating when Bradley discovered that my property wasn't subject to the same HOA restrictions as newer developments and couldn't be controlled through the community association rules he was attempting to implement throughout Crystal Lake Estates. During our first formal meeting, he'd suggested that I might want to consider modernizing my property ownership structure to take advantage of contemporary asset management opportunities. When I politely explained that federal judges maintain strict ethical guidelines about property investments and that my lake house would remain a simple personal residence under traditional ownership structures, Bradley's demeanor shifted from fake cooperation to barely concealed hostility. His pink dress shirt seemed to tighten across his gut as his face reddened with the kind of anger that comes from someone unused to being told no by anyone, especially federal judges who understand property law better than real estate speculators. The harassment started when Bradley began researching legal ways to acquire valuable lakefront properties through regulatory pressure, HOA assessments, and what he called community improvement initiatives that would force property transfers to more commercially oriented owners who could maximize waterfront development potential. That evening, as I sat in my judicial library reviewing federal court opinions on property rights while watching sunset reflect off Crystal Lake, I realized that Bradley had made a fundamental miscalculation about his opponent. He'd assumed I was just another wealthy property owner who could be intimidated through legal complexity and bureaucratic pressure, involving foreclosure procedures and HOA authority. What he didn't know was that I was the federal judge who'd written the legal precedents he was about to violate, authored the constitutional decisions that protected property owners from exactly his type of fraudulent schemes, and possessed the judicial authority to expose and prosecute the criminal foreclosure fraud he was planning to use against my family's lakefront property. Bradley's final mistake was underestimating his opponent while simultaneously providing me with evidence of systematic targeting of valuable properties for criminal acquisition through fraudulent legal processes that violated federal law, constitutional protections, and the judicial precedents I'd spent 3 decades establishing to protect American families from exactly this type of property theft. Bradley's first official assault came on a crisp October morning when I found him standing on my dock with his clipboard pink dress shirt, already showing sweat stains despite the cool mountain air, as he photographed my lakefront property from multiple angles while speaking into a digital recorder about underutilized community assets and non-compliant waterfront modifications. The smell of his cologne mixed with pine needles and lake water as he scribbled notes with the intensity of someone documenting federal crimes rather than conducting a property assessment. "Morning, Judge Harrison," he called out with fake friendliness, his voice echoing across the still water where morning mist rose from the lake like smoke from a campfire. "Just conducting the quarterly asset utilization review required by updated HOA community enhancement protocols. Your waterfront property appears to violate several recently implemented value optimization standards." The violation notice he handed me was professionally printed on Crystal Lake Estates letterhead, complete with legal citations and a 30-day deadline for compliance. The document was a masterpiece of bureaucratic intimidation, citing property utilization requirements, community asset enhancement obligations, and waterfront development standards that supposedly applied to my judicial retreat despite federal ethics rules that specifically govern judicial property ownership. Bradley had done extensive research, consulting with foreclosure attorneys, property acquisition specialists, and legal services to create the appearance of legitimate HOA authority, while systematically targeting the most valuable lakefront properties for acquisition through fabricated assessments and regulatory harassment. The violations ranged from inadequate property utilization to non-compliant waterfront improvements to what he termed underutilized community assets that allegedly violated community property value enhancement requirements. Each violation carried assessments ranging from $2,000 to $8,000, with daily accumulation until compliance was achieved through either expensive property modifications or voluntary sale to community-approved buyers who would maximize waterfront development potential. The total potential assessments exceeded $47,000, obviously calculated to force either ruinously expensive compliance or property transfer to Bradley's development network. The genius of Bradley's strategy was its systematic complexity designed to overwhelm property owners with legal-sounding requirements that appeared legitimate while actually violating established property law, constitutional protections, and federal judicial ethics regulations that governed how federal judges could own and maintain personal property. What Bradley didn't realize was that he'd just handed detailed evidence of his systematic property acquisition scheme to the federal judge who specialized in property rights law, had authored the constitutional precedents that protected homeowners from exactly this type of fraudulent harassment, and possessed the judicial authority to expose and prosecute organized property theft disguised as community governance. The harassment campaign expanded throughout October as Bradley recruited other HOA board members to join his systematic documentation of alleged violations that would justify property seizure through fabricated assessments and fraudulent foreclosure procedures. Board Secretary Gerald Morrison began photographing my property improvements, claiming authority to assess waterfront compliance with community enhancement standards. Treasurer Sandra Phillips conducted what she called asset utilization evaluations of my lakefront property, documenting usage patterns that allegedly violated community property value optimization requirements. The coordinated nature of their activities revealed this wasn't random property assessment, but an organized campaign to acquire valuable lakefront properties through systematic legal harassment. My 3 decades of federal judicial experience had taught me to recognize organized criminal enterprises, and Bradley's operation displayed all the hallmarks of systematic property fraud that used legitimate-appearing legal processes to steal valuable real estate from property owners who lacked the legal expertise to recognize and fight back against fraudulent procedures. The escalation continued when Bradley began filing complaints with federal agencies about my judicial property, demonstrating either remarkable ignorance of federal judicial ethics law or criminal intent to interfere with federal judicial operations through harassment of federal judges and their families. The Federal Judicial Conduct Committee received reports about inappropriate property utilization that allegedly violated judicial ethics requirements. The Administrative Office of U.S. Courts got complaints about my lakefront property supposedly violating federal judicial property ownership guidelines, when federal law actually protected judicial property rights and prohibited exactly the type of harassment Bradley was conducting. Each federal complaint triggered investigations that forced me to take time away from federal court duties to defend property rights that were clearly established in federal judicial ethics regulations. Bradley had essentially weaponized federal agencies against a federal judge, turning government oversight systems into unwitting accomplices in his property acquisition scheme designed to steal valuable lakefront properties while creating the appearance of legitimate regulatory enforcement. The psychological warfare intensified when Bradley began organizing community asset optimization meetings to discuss what he called underutilized waterfront properties that allegedly threatened community property values and development potential. These gatherings, held in Crystal Lakes Community Center, featured PowerPoint presentations about property value enhancement, community asset management, and development opportunities that allegedly justified acquiring underutilized properties for community benefit. Bradley positioned himself as the community development advocate, fighting to preserve property values against property owners who refused to maximize their waterfront investments through appropriate commercial development and community enhancement initiatives. The meetings were carefully orchestrated propaganda sessions designed to build resident support for aggressive property acquisition while creating legal cover for his systematic theft scheme. By framing my judicial retreat as a threat to their property value investments, Bradley transformed ordinary neighbors into willing participants in his campaign to acquire valuable lakefront properties through fabricated assessments and fraudulent foreclosure procedures. The financial pressure escalated when Bradley's HOA began assessing what they called community enhancement fees against my property, claiming these fees were authorized by waterfront property optimization requirements and community asset management protocols. These assessments, totaling $23,400, were allegedly required to fund community improvements necessitated by underutilized properties that supposedly reduced overall community property values. The breaking point came when Bradley coordinated with Lakefront Legal Services to file a formal foreclosure action claiming my property was subject to immediate seizure for unpaid HOA assessments and community enhancement obligations. His evidence included property utilization assessments alleging noncompliance, community impact studies claiming property value damage, and legal opinions supporting HOA authority to acquire underutilized community assets. The foreclosure filing revealed Bradley's ultimate strategy. The moment Bradley filed that fraudulent foreclosure action against my lakefront property, he crossed the line from harassment into federal criminal territory, and my 34 years of federal judicial experience kicked into full investigative mode that would systematically dismantle his entire criminal enterprise. I spent the following weekend in my judicial chambers, surrounded by federal statutes, constitutional precedents, and the comprehensive case law I'd helped establish during 3 decades on the federal bench, building what prosecutors would later call the most thorough property fraud investigation in federal court history. What Bradley didn't know was that Judge William Harrison had literally authored the federal judicial precedents he was about to face, including the landmark Harrison v. Property Fraud Network's decision that established federal jurisdiction over systematic property theft schemes targeting federal officials and their families under 18 U.S.C. Section 1961 of the RICO Act. My investigation began with Bradley's foreclosure filing, and the document was a masterpiece of criminal fraud that would have impressed organized crime attorneys. He'd claimed I owed $87,000 in HOA assessments when my property had never been subject to such obligations, fabricated legal authority that didn't exist under Colorado law, and forged signatures from attorneys who had no standing to file foreclosure actions against federal judicial property. But the smoking gun was the document's legal citations. Bradley had referenced federal cases that I had personally decided, misquoting my own judicial opinions to support foreclosure procedures that my decisions had specifically prohibited. The irony was devastating. He was using my own legal precedents, incorrectly interpreted, to justify stealing my property. The federal implications became clear when I traced Bradley's financing through judicial administrative channels and federal law enforcement databases. Bradley had been systematically acquiring lakefront properties throughout Colorado using identical fraud schemes, creating a criminal enterprise worth over $67 million in stolen waterfront real estate through fabricated foreclosures and regulatory harassment. When property fraud involves federal officials and crosses state lines, it triggers federal RICO jurisdiction under 18 U.S.C. Section 1961, transforming neighborhood harassment into organized crime with mandatory minimum sentences of 20 years in federal prison. My analysis revealed Bradley had been coordinating with corrupt officials in Colorado, Utah, Montana, Wyoming, and Arizona, sharing tactics for targeting federal employees and judicial personnel through systematic property theft. I contacted FBI Special Agent Jennifer Martinez first. We'd worked together on judicial security issues for over a decade. Judge Harrison, this sounds like the Denver foreclosure fraud ring we prosecuted in 2019, she said, referencing a similar scheme we'd dismantled. Same methodology, same shell company structure. I'll assign a federal task force immediately. Next was U.S. Attorney David Chen from the Colorado District Office. Your Honor, targeting federal judges with property fraud constitutes federal crimes under multiple statutes, including 18 U.S.C. 241 and 242. We'll open a criminal investigation with full federal resources. The U.S. Marshals Service was particularly concerned when I explained Bradley's systematic targeting of federal judicial property. Chief Deputy Marshal Sarah Rodriguez had been tracking similar operations. Judge, this isn't random HOA harassment, it's systematic targeting of federal officials under 18 U.S.C. 372. That triggers federal protective jurisdiction and enhanced penalties up to life imprisonment. Within 48 hours, I had a federal task force that included FBI financial crimes specialists, U.S. Marshals, federal prosecutors, IRS criminal investigators, and Postal Inspection Service agents. We established our command center in the federal courthouse, complete with evidence analysis systems, financial investigation software, and enough federal firepower to dismantle international criminal organizations. The investigation revealed Bradley's operation was more sophisticated than typical property fraud. He'd established multiple LLCs to hide criminal activities: Lakefront Management Associates, Collections, Mountain Property Advisors, Legal Services, and Colorado Asset Enhancement Acquisitions. Each company had different registered agents, but financial analysis showed they all led back to Bradley's personal accounts and criminal network. We discovered Bradley had been paying federal bankruptcy trustee Gerald Morrison $127,000 in consulting fees to expedite fraudulent foreclosure procedures and provide inside information about vulnerable federal employees' properties. Environmental lawyer Sandra Phillips received $89,000 for filing false federal complaints against targeted property owners. Even the foreclosure attorney was on Bradley's payroll, receiving $67,000 to file fraudulent legal actions with fabricated evidence. The money trail was beautiful in its criminal simplicity. HOA assessments: right arrow Lakefront Management, right arrow shell companies, right arrow Bradley's personal accounts, right arrow bribes to corrupt officials, right arrow more property theft. The forensic accountant from the Justice Department called it textbook racketeering with federal official targeting enhancements under RICO statutes. But the real breakthrough came when we executed federal search warrants simultaneously across 5 states under the Patriot Act's expanded authority for crimes targeting federal officials. At Bradley's home office, we found the Criminal Enterprises Operational Center, pre-printed foreclosure notices, rubber stamps reading delinquent and SEIZED, and a computer folder labeled Federal Targets containing detailed files on federal judges, prosecutors, and law enforcement personnel who owned valuable properties. In his computer, we discovered the Judicial Acquisitions spreadsheet with tabs for target properties, assessment amounts, foreclosure timeline, and distribution schedule. The distribution schedule showed Bradley had paid himself $340,000 in management fees from fraudulent property seizures, while his criminal network received smaller amounts for their participation. The email evidence was devastating. Bradley to Lakefront Management: federal judges think they're untouchable. Increase pressure on Harrison property. Judicial ethics will prevent him from fighting back effectively. Reply from the foreclosure attorney: avoid theft in documentation. Use community enhancement. If seizure is mentioned, say asset optimization. Most damning was Bradley's correspondence with similar operations targeting federal officials in other states. He'd been sharing victim lists, legal strategies, and corrupt official contacts through encrypted communications. The network included property fraud operations in Utah, Montana, Wyoming, Arizona, and New Mexico, all using Bradley's playbook to steal federal employees' valuable properties. Federal wiretaps authorized under judicial security provisions revealed Bradley's true motivations during recorded conversations with out-of-state criminal associates. Federal judges make perfect targets, he bragged. They think their legal knowledge protects them, but they can't use their judicial position to fight HOA assessments. Create enough bureaucratic pressure, and they'll transfer property rather than compromise their judicial ethics. The investigation took 11 months and filled 63 evidence boxes with documents, recordings, and digital evidence. We identified 87 victims across 6 states who'd lost property to Bradley's network, with total losses exceeding $67 million in stolen real estate belonging to federal employees, military personnel, and law enforcement families. The federal grand jury returned indictments on 147 charges: racketeering under 18 U.S.C. 1962, mail fraud under 18 U.S.C. 1341, wire fraud under 18 U.S.C. 1343, money laundering under 18 U.S.C. 1956, conspiracy under 18 U.S.C. 371, obstruction of justice under 18 U.S.C. 1503, and systematic targeting of federal officials under 18 U.S.C. 372. Bradley faced additional charges for filing false federal reports, interfering with federal judicial operations, and conspiracy to deprive federal officials of property rights under color of law. But Bradley had no idea the federal net was closing. While federal agents gathered evidence, he continued his harassment campaign, filing more fraudulent foreclosure actions and making more threats against federal judicial property. Every crime he committed was being monitored and documented by federal investigators who specialized in protecting federal officials from criminal targeting. The beautiful irony was that Bradley thought he was pressuring some wealthy federal judge into surrendering valuable lakefront property. What he'd actually done was provide federal prosecutors with the most comprehensive property fraud case in federal court history, complete with recorded confessions, financial evidence, and a criminal network that had systematically targeted federal officials across 6 western states. Bradley's next move would be his last as a free man, because the federal judge he'd been harassing was about to demonstrate exactly what happens when organized criminals target federal judicial personnel with systematic property theft schemes that violate federal law, constitutional protections, and the judicial precedents designed to protect American families from exactly the crimes Bradley had been committing. Bradley's desperation reached criminal insanity when he decided to escalate from fraudulent foreclosure filings to actual property seizure. And the morning he made that fatal mistake, federal agents were positioned throughout Crystal Lake Estates, documenting every federal crime he committed against a sitting federal judge. December 15th dawned clear and cold, the kind of Colorado winter morning where the lake reflects snow-covered peaks like a mirror, and the air carries sounds for miles across the frozen landscape. Bradley arrived at my lakefront property at 8:23 a.m. with a convoy that looked like a federal raid. Moving truck, private security vehicle, locksmith van, and what appeared to be a U.S. Marshal's car. The Marshal was legitimate, but had been deceived by Bradley's forged federal court orders. Bradley climbed out of his white Escalade wearing his signature pink dress shirt and black dress pants, clipboard pressed against his chest like armor, absolutely convinced he'd found the federal authority to seize lakefront property from a sitting federal judge. What Bradley didn't know was that FBI agents were recording everything from 6 surveillance positions. U.S. Marshals were documenting each federal crime as it occurred, and I was coordinating the entire operation from my judicial chambers, wearing federal recording equipment that captured every word of his confession to systematic targeting of federal judicial personnel. The federal seizure order Bradley presented was a masterpiece of criminal forgery that would have impressed international document fraud specialists. Complete with fabricated federal court seals, forged judicial signatures from my own court, and legal citations that reference cases I had personally decided, the document was designed to overwhelm property owners with apparent federal judicial authority. My 3 decades of federal judicial experience had taught me to spot fraudulent court orders from across a courtroom, and Bradley's forgery was obvious to anyone who'd actually seen real federal seizure documents. The case number format was wrong, the judicial signature was traced from publicly available court documents, and the legal authority cited was from cases that specifically prohibited the property seizures Bradley was attempting to authorize. When I calmly identified myself as Chief Judge William Harrison and explained that his seizure order was fraudulent, the private security team immediately backed away from Bradley's operation faster than defendants fleeing a federal courthouse. Your Honor, if there's any question about federal authority, we're not participating in property seizure, the security supervisor said, his voice carrying the weight of someone who understood the consequences of interfering with federal judicial property. Bradley's response revealed the true depth of his criminal delusion and anti-judicial bias. This is legitimate federal property enforcement that supersedes individual judicial positions, he screamed, his voice rising with panic as his scheme collapsed in real time. Valuable community assets don't get immunity from seizure just because someone wears judicial robes. Federal property law applies to everyone equally, including federal judges who think they're above community standards. The federal recording equipment captured every word as Bradley confessed to systematic property fraud while demonstrating criminal intent to steal federal judicial property under 18 U.S.C. 241, conspiracy against rights, and 18 U.S.C. 242, deprivation of rights under color of law. His backup plan revealed even deeper criminal desperation when he produced what he claimed were Department of Justice seizure orders, requiring immediate transfer of judicial property to community asset management authorities. Bradley had forged Department of Justice documents, complete with official letterhead and federal agency seals, each forged document carrying a mandatory minimum sentence of 20 years in federal prison under 18 U.S.C. 495 forgery of federal documents. The psychological warfare escalated when Bradley began making threats that revealed his systematic plan to eliminate federal judges from valuable property ownership. You think your federal judge position protects you from property law and community asset optimization, he said, pointing aggressively while sweat poured down his face despite the cold weather. But valuable lakefront properties don't get judicial immunity. Community enhancement and asset optimization apply to everyone, including federal judges who refuse to maximize property values. The Federal Wire captured Bradley's detailed knowledge of my judicial position, his systematic plan to acquire federal officials' properties, and his belief that community development interests could override federal judicial property rights through fabricated federal authority. Clear evidence of violations under 18 U.S.C. 372, conspiracy to impede or injure officer. The climax came when Bradley ordered federal bankruptcy trustee Gerald Morrison to begin physically securing my lakefront property with chains and padlocks, claiming immediate federal seizure authority despite the security firm's refusal to participate and the presence of the federal judge whose property was being targeted. Gerald, unaware that U.S. Marshals were watching from multiple positions, began attempting to chain my gates while Bradley supervised with his clipboard and fraudulent federal seizure orders. U.S. Marshal Sarah Rodriguez moved in when Bradley and Gerald attempted to secure federal judicial property, transforming his fraud scheme into actual criminal theft occurring in the presence of federal law enforcement officers under 18 U.S.C. 111, assaulting, resisting, or impeding federal officers. Mr. Whitmore, Marshal Rodriguez said, her voice carrying the authority of someone who'd arrested international criminals and corrupt federal officials. You're under arrest for systematic property fraud, racketeering, and criminal targeting of federal judicial personnel. The color drained from Bradley's face faster than water from a broken dam as he realized his theatrical property seizure had been a federal sting operation designed to catch him committing crimes, while federal prosecutors built cases that would send him to prison for the rest of his life. Bradley's arrest was captured on multiple federal recording devices as marshals documented every aspect of his criminal operation. His pink dress shirt was soaked with sweat as Marshal Rodriguez read him his rights while other marshals photographed the forged federal documents, secured the lakefront property, and arrested Gerald Morrison for participating in criminal theft of federal judicial property under 18 U.S.C. 371, conspiracy. The federal investigation expanded dramatically when marshals discovered Bradley's coordination with property fraud operations targeting federal officials in Utah, Montana, Wyoming, New Mexico, Arizona, and Nevada. His harassment of my lakefront property was part of a systematic criminal enterprise that specialized in stealing valuable properties from federal judges, prosecutors, and law enforcement families across the American West. Bradley hadn't just been harassing one federal judge. He'd been running a criminal organization that specialized in targeting federal officials' properties across multiple states, with total losses exceeding $67 million in stolen real estate belonging to federal employees and their families. The evidence trail revealed systematic targeting of federal judicial personnel whose valuable properties interfered with commercial development plans. The federal grand jury returned a superseding indictment with 163 federal charges. Racketeering under 18 U.S.C. 1962, c. The federal courthouse in Denver had never seen anything quite like United States v. Bradley Whitmore and Associates, and the irony wasn't lost on anyone that Bradley would face sentencing for systematic property fraud targeting federal officials, while sitting in the same federal judicial system he'd attacked through his criminal enterprise. Due to obvious conflict of interest, I had recused myself from Bradley's criminal case, but Chief Judge Patricia Martinez, my longtime colleague, would handle his sentencing with the judicial precision that makes federal sentences educational experiences for criminals who target federal officials. The courtroom was packed beyond capacity with federal judges, U.S. attorneys, federal agents, and property rights advocates who traveled from across the western United States to witness what prosecutors called the most comprehensive property fraud prosecution targeting federal officials in federal court history. Bradley sat at the defendant's table in his orange prison jumpsuit, his pink dress shirt and black dress pants replaced by federal detention clothing, looking like a deflated balloon as he faced consequences for systematically targeting federal judicial personnel. The evidence presentation took 14 days and filled federal court records with overwhelming documentation of Bradley's systematic property fraud criminal enterprise. Federal prosecutors presented 3,247 pieces of evidence. Wire recordings of Bradley confessing to federal crimes while attempting to steal my lakefront property, photographs of forged federal court documents, financial records showing $67 million in stolen properties belonging to federal officials, and testimony from 87 federal employees who'd been targeted by Bradley's systematic theft campaigns. The scope of his criminal organization was staggering. Corrupt officials in 8 states, fraudulent legal services specializing in targeting federal employees, and a sophisticated network designed to eliminate federal officials from valuable property ownership through systematic theft, while corrupting local and federal systems to provide legal cover for criminal activities targeting constitutional government. My victim impact statement, read by the federal prosecutor since I couldn't participate directly in Bradley's sentencing due to recusal requirements, provided the court with detailed analysis of his criminal methods and their broader implications for federal judicial independence and constitutional protections. Your Honor, the prosecutor read on my behalf, the defendant didn't just attempt to steal my lakefront property through fraudulent foreclosure procedures and forged federal court documents. He systematically undermined federal judicial independence by targeting federal judges with criminal harassment, designed to eliminate federal officials from property ownership that might conflict with his commercial development interests. His actions represent domestic terrorism, specifically targeting federal judicial personnel and constitutional government. His criminal organization poses ongoing threats to federal judicial independence and the constitutional separation of powers that protects federal officials from exactly this type of criminal targeting and systematic harassment designed to compromise the integrity of federal court operations. The financial destruction was swift and comprehensive, as federal forfeiture proceedings under 21 U.S.C. 853 seized every asset Bradley had acquired through criminal activity. His Crystal Lake Estates development, valued at $340 million, was forfeited to compensate victims and restore properties to rightful federal employee owners. His personal mansion, luxury vehicles, investment accounts, and criminal enterprise assets were liquidated to fund complete restitution to 87 federal families he'd victimized. Bradley's entire lifestyle, built on stealing federal officials' properties and undermining constitutional government, was dismantled by federal agents who specialized in protecting federal personnel from criminal targeting. Bradley's co-conspirators faced federal justice as his criminal organization collapsed under prosecution designed to protect federal officials and constitutional governance. Federal bankruptcy trustee Gerald Morrison received 34 years for conspiracy and systematic targeting of federal officials under 18 U.S.C. 372. His federal position forfeited and pensions seized for victim restitution. Environmental lawyer Sandra Phillips received 28 years for criminal conspiracy to steal federal employees' protected properties through systematic fraud and corruption. The corrupt federal and state officials who'd enabled Bradley's targeting faced sentences ranging from 22 to 38 years for systematic violation of federal employee protection laws. Chief Judge Martinez's sentencing remarks became legendary in federal judicial circles for comprehensive protection of federal officials and condemnation of criminal enterprises targeting constitutional government. "Mr. Whitmore," she said, looking directly at Bradley as he sat trembling in his orange jumpsuit, "you have systematically victimized federal officials through a criminal organization that specialized in property theft disguised as community development, while targeting the constitutional independence of federal judicial personnel. Your elimination of federal officials from property ownership represents an attack on constitutional government that threatens the foundation of federal judicial independence and the separation of powers that protects our constitutional system from exactly this type of criminal targeting and systematic corruption designed to compromise the integrity of federal institutions." The sentence was devastating and final. 42 years in federal prison without possibility of parole under 18 U.S.C. 3559C, followed by 25 years of supervised probation with restrictions on real estate activities, contact with federal officials, and residence in communities where federal employees own property. Bradley would be 101 years old before his release, and federal probation conditions would prevent him from ever again engaging in activities that could threaten federal officials. The civil judgment was equally comprehensive as federal court awarded $47.3 million in damages for property fraud, systematic targeting of federal officials, and criminal interference with federal judicial operations under 42 U.S.C. 1983. The judgment included punitive damages designed to deter similar criminal activities and compensate federal families for years of harassment and property theft designed to compromise federal government operations. The legislative impact extended beyond individual justice as Congress passed the Federal Official Protection Act, strengthening penalties for systematic targeting of federal employees under enhanced versions of 18 U.S.C. 372 and creating enhanced security protocols for federal officials' property ownership. The Harrison Amendment established federal criminal penalties for harassment of federal judicial personnel and systematic targeting of constitutional officers, with mandatory life sentences for organized criminal enterprises. My lakefront property continues serving as a judicial retreat, where constitutional questions receive thoughtful consideration in an environment that honors both natural beauty and constitutional governance. The property became a symbol of successful resistance to criminal targeting of federal officials and constitutional government, hosting annual conferences on judicial independence and constitutional protection. The annual Constitutional Heritage Day celebration at Crystal Lake draws federal officials, constitutional scholars, and property rights advocates who celebrate both constitutional governance and property rights protection. The event honors federal officials who have successfully defended constitutional principles while protecting the property rights that sustain constitutional government and the rule of law. Bradley's story became a cautionary tale taught in federal law enforcement training programs about protecting federal officials from criminal targeting and investigating systematic enterprises that threaten constitutional government. His systematic harassment of one federal judge triggered the largest property fraud investigation targeting federal officials in federal court history, destroyed a criminal organization operating across 8 states, and resulted in federal legislation protecting constitutional officers from property theft designed to compromise government integrity. The lake still reflects snow-covered peaks in morning light that has inspired judicial contemplation for generations. The Judicial Library still houses constitutional research that informs federal court decisions affecting millions of Americans. And the property still provides the kind of peaceful environment where federal judges can write thoughtful opinions that protect constitutional rights and property ownership throughout our nation. But now it also serves as a reminder that federal officials deserve protection from criminal targeting, that property fraud can be defeated through